Yeas pour 39-39. Nays contre 36-36. Abstentions, abstentions 5-5.
Accordingly, the motion is carried. Honourable Senators, before resuming debate on the main motion, un message a été reçu de la Chambre des communes avec le projet.
We have Bill C-45 entitled
Development Act, pour lequel elle sollicite l'agrément du Sénat.
when we're seeking the approval of the Senate.
First reading of this bill, première lecture de ce projet de loi.
When shall this bill be read a second time? Senator Harder.
Honourable Senators, I move that this bill be placed on orders of the day for second reading 2 days hence.
Moved by the Honourable Senator Harder, seconded by the Honourable Senator Isabel Mar, that this bill be placed on orders of the day for second reading 2 days hence. Is it your pleasure, Honourable Senators, to adopt the motion? Resuming debate on the main motion, C-45, Senator Platt.
Thank you, Speaker. Honourable Senators, I also rise today to speak to third reading of Bill C-45. The responsibility lies upon all of us in this chamber to ensure that when cannabis is legalized, it is backed by a legislative framework that will keep our citizens, most importantly our children, safe. This is a goal that the Liberal government has repeatedly stated is paramount, and yet they have fallen short in a number of areas. However, I know that the protection of youth is a goal shared by all members of this chamber. Colleagues, last week during clause-by-clause consideration of this bill, Senator Bernard proposed a two-part amendment that sought to ensure that our Canadian youth were not unduly criminalized. Senator Bernard's amendment dealt with two issues regarding the use and consumption of cannabis by minors. Bill C-45 reads, and I quote, "It is prohibited for an individual who is 18 years of age or older to distribute cannabis to an individual who is under 18 years of age." The first section of Senator Bernard's amendment sought to void this provision of the bill in the event that the individual over the age of 18 was less than 2 years older than the individual to whom they distribute cannabis. In committee, Senator Bernard carefully presented the intent of her amendment, citing the prevalence of the social sharing of cannabis amongst youth who are close in age. As Senator Bernard stated, it is quite common for young adults to have friends and peers that are slightly younger, and thus we do not want to unduly criminalize individuals of these ages for sharing their cannabis with their peers in a social situation. In effect, this amendment would allow an 18-year-old to share their legally purchased cannabis with an individual as young as 16 years of age without any repercussion. This amendment does not lessen the punishment, colleagues, it eliminates it. It makes it lawful, permissible for an 18 and 19-year-old to share cannabis with their younger friends who are not of legal age. As Senator Bernard stated in committee, the penalty associated with providing cannabis to a minor carries a prison sentence of up to 14 years. Of course, the maximum sentence would be for the most egregious of cases, not the minor incidents that Senator Bernard is referring to in her description of social sharing. As I stated, this amendment makes the practice of an 18-year-old sharing marijuana with a 16-year-old absolutely lawful. And further to that, colleagues, most alarmingly, there is no cap on the amount of cannabis one can provide in this context. While the sentiment is entitled social sharing, which was to capture the practice of an 18 or 19-year-old sharing a bit of marijuana in a social setting, with Senator Bernard's amendment, an adult of this age can provide literally any amount of cannabis to their younger peers. This will be known, and make no mistake, colleagues, it will be abused. Keep in mind, there is no such exemption in any province if an of-age adult buys alcohol for a younger peer. It is well known among Canadian youth that this is against the law, as it should be. There is no reason why sharing marijuana should be subject to a different standard. While they may be peers, at the end of the day, this law applies to adults and their provision of cannabis to minors. There must be consequences, colleagues, and no, those consequences, in the very limited circumstances outlined by Senator Bernard, should not consist of a serious indictable criminal offense. With respect to the second part of Senator Bernard's amendment, I do not personally support parents being permitted to provide their teenage children with marijuana, as I believe the medical community has been clear on the impact of this drug on developing brains. However, we do not have such exceptions for alcohol in every province, in which a parent or guardian in their dwelling house can provide alcohol to their child 16 years of age or older. So, for the sake of consistency and reasonableness in law, I leave this provision alone. However, there is no precedent for the proposal respecting social sharing among peers. This amendment simply cannot stand as is. There needs to be responsibility and accountability surrounding cannabis. End of story. I am proposing that we do not make social sharing from an adult to a minor peer strictly permissible and lawful, but that we reinstate a penalty that is drastically reduced from the bill's original proposal. We worked with the law clerk's office to come up with what we believe to be an appropriate solution. In honoring the spirit of the social sharing proposal, we have kept the 2-year proximity limit for sharing amongst peers, and we make it clear that this individual is not to be prosecuted by indictment. Instead, we concluded that ticketing would be an appropriate option for police and have left the summary process as already outlined in the legislation intact. But there will not be an indictable offense associated with social sharing. In this amendment, we have also provided a limit to social sharing. For consistency, we use the 5 grams of marijuana, which is provided for elsewhere in the bill when it comes to youth possession. 5 grams, colleagues, is a lot of marijuana. As we have heard repeatedly, that is 10 joints. That, colleagues, is a very generous cap on social sharing. Beyond that, any adult who provides a minor with cannabis in excess of 5 grams, regardless of proximity and age, will not be covered under this social sharing provision and will be guilty of an indictable or summary offense as already outlined in the legislation. With that said, I move that Bill C-45 be not now read a third time, but that it be amended. A, in Clause 9 on page 10, by replacing subsection 2.1, added by decision of the Senate on May 30th, 2018, with the following. 2.1, subparagraph 1A2 does not apply if cannabis is distributed to an individual who is 16 years of age or older by their parent or guardian in their dwelling house, and, on page 11, by adding the following after line 6. 5.1, despite paragraph 5A, a charge arising out of a contravention of subparagraph 1A2 in respect of cannabis, one or more classes of cannabis, the total amount of which, as determined in accordance with Schedule 3, is equivalent to 5 grams or less of dried cannabis, is not to be prosecuted by indictment if the accused is less than 2 years older than the individual referred to in that subparagraph. B, in Clause 51, on page 29, by adding the following after line 20. A1, proceedings in respect of an offense arising out of a contravention of subparagraph 9, 1A2, in respect of cannabis, of one or more classes of cannabis, the total amount of which, as determined in accordance with Schedule 3, is equivalent to 5 grams or less of dried cannabis. If the accused is less than 2 years older than the individual referred to in that subparagraph. And C, on page 127, by replacing the references after the heading Schedule 3 with the following. Subsection 2, sub 4, paragraphs 8, 1A, and C, subparagraphs 9, 1A1 and B, B1, paragraphs 5.1, 2A, A1, and C2F, and subsection 151, sub 2. Thank you.
In amendment, it was moved by Honourable Senator Platt, seconded by the Honourable Senator Martin, that Bill C-45 be not now read a third time, but that it be amended. A, in Clause 9. On debate. Oh, I'm sorry, Senator Munson. Senator Platt, would you accept the question?
Yes, certainly.
You have a minute.
Senator Platt, how would you enforce this? A policeman in every home?
Well, I wouldn't enforce it. Number one, I am astounded by that question. How is giving alcohol away enforced? There is no, I'm not suggesting that parents are not allowed to give the marijuana to their children. I've stated that, as you obviously heard. This is for people giving marijuana to 16-year-olds. So how do police enforce when an 18-year-old gives alcohol to a 16-year-old? We have fine law enforcement officers that I expect will do their absolute best to enforce the law as is intended.
Senator Bernard, on debate. Your time is up.
Thank you, Madam Speaker. Honorable colleagues, I'm speaking against Senator Platt's amendment to my amendment. The amendment I made at Social Affairs study of this bill was created, the amendment created an exemption to any criminal penalties for social sharing amongst young people. And let's keep in mind, colleagues, that we're talking about sharing of a legal substance, if this is legalized. This was a recommendation that was made by the task force, and they noted that there should be an exclusion for social sharing. Social sharing typically means the sharing of one joint in a social setting, in a social context. We heard from witnesses that the bill, as it was worded, would be problematic for young people in this way. Criminal defense attorneys Friedman and Robichaud talked about the need to do all we could to decriminalize and focus on education for young people. Another criminal lawyer that we heard from, Mr. Tousaw, talked about the close in age issue as being a very serious one, social sharing. However, I believe that the most compelling evidence came from a young person herself. Many senators, many witnesses have talked about protecting young people, have talked about decriminalizing because of our concern for young people. We didn't hear directly from many young people as expert witnesses. We heard people speak about them. The young woman that I want to share some comments from her testimony is named Kristen Sardi. She gave evidence to the Social Affairs Committee on Wednesday, April 25th. She's an advanced peer worker and an alumni of EVA's initiatives. She says, I am a 25-year-old advanced peer worker based out of EVA's satellite in Toronto. Her testimony is compelling, and she was speaking not just about her own experience, but based on her work with other young people as well. I want to quote from her. She says, I believe that having peer programs in schools, community support groups, and educational workshops will benefit young users compared to being charged for something most young people do at some point in their lives anyway. She went on to say, why would we charge a 14-year-old with marijuana charges when we really need to see why they are using in the first place and how we can help them make other choices. Through all this, I've never been arrested for weed charges. I think if I would have had charges when I was under 18, or even now, it would have held me back in my progress. The laws should be supporting young people, not penalizing them. Living in the youth shelter, youth ages range from 16 to 24. In accordance to the laws being implemented, if I were to give my friend who's under age 18 a joint or some weed, I could potentially be charged with an indictable offense. These friends come to me to get advice or use smartly, but now this law will put me at risk of getting a criminal record. Do I risk a criminal record or risk potential harm to an uneducated friend? I'm working hard. I'm working towards getting my security license, as well as becoming a community worker. This would severely hinder my progress and potentially close many doors for me. And of course, that's the message we heard from many adults who are seeking to protect young people. So the close in age, if we were to support this amendment, I think we'd be opening the door again for discretion. And we've already heard, again, many colleagues, many of you honorable senators have spoken about the systemic discrimination that we know follows discretion. So even the ticketing that's being proposed. We're not talking about trafficking. We're talking about social sharing, which is totally different. So I will be speaking, I will not be supporting the proposed amendment.
Senator Dick has her first, she was the first name on the
For question
list.
Yes. Thank you for your comments, Senator Bernard. I was following the discussion about social sharing, and I understand that. But what the question that in my mind is this: what if it's a person who's less than 2 years older, but not necessarily a friend, who might actually be someone who's linked to, a drug dealer or whatever, whose intentions are not so innocuous, and the intention is to entice the person, to get the person hooked? So that was my question. This sounds like this amendment doesn't make that distinction between social sharing, which is one thing, versus a deliberate intention to entice the person. So it's only talking about age, not about intention.
Senator Bernard?
Of course, the whole question of intention is a difficult one to get to. One of the things that we know would clearly need to happen is education, and the education about safety, about safe use, is so important, and we will be better able to do that education outside of a criminal process.
Senator Lankin was before you, Senator Platt. Senator Lankin?
Thank you very much, Your Honor. Senator Bernard, I understand the issue that you make around the use or misuse of discretion and its particular impact on racial minorities and other minority groups. So I'm with you on that. I was very supportive when you brought the amendment forward at committee, but I think I didn't ask enough questions. So when I listened to Senator Platt, one of the things I wonder here is, did we provide a definition of social sharing? Because I immediately thought of the scenario that you talk about, which is where someone is passing a joint around a room where kids are partying or just hanging out or whatever. Senator Platt says, yeah, but it could also be a large amount that is being given, not just one joint being passed. It could be actual provision. I can go and buy it legally, so now I'm going to give you my, my 5 ounces or whatever. And there's not supposed to be a legal way for minors to get this. So what Senator Plett is suggesting with the ticketing scheme takes it out of the indictable and criminalization. Can you tell me why you would still oppose that? And if you do, should we be providing a definition of social sharing, or did we?
Senator Bernard, you have a minute.
Thank you. Thank you for the question, Senator. And you raise an important point about the lack of definition. So you're right. No, we did not provide a definition, and I think that would bring greater clarity to that amendment that was passed. Sorry, I forget the second part of your question. I'm sorry.
If there is no definition, it actually opens the situation to larger quantities being shared as a quantity as opposed to the passing of one joint. And I think that is the caution that Senator Plett's trying to raise for us, and I think he might be right.
So while I would agree that having a definition would be helpful, I don't agree with the ticketing, because I think the ticketing would, again, disproportionately affect groups who are already disadvantaged.
There's 19 seconds left, Senator Platt.
Thank you. Senator Bernard, I think I have absolutely done everything that you just said in your speech to me that you wanted. I think you made my case as well as I did. I have got the definition that Senator Lankin is talking.
Thank you, Senator Platt. Senator Martin, you're on debate.
Thank you. Honourable Senators, I rise in support of the amendment moved by Senator Plett and the two-part amendment adopted at committee introducing social sharing provisions to C-44 left as is will have far-reaching consequences, both anticipated and unanticipated, for Canadians across this country, especially our youth. And if I may perhaps link back to some of the questions that were being asked, as well as what Senator Plett said, one of the areas that I'm quite concerned about is what will happen in the schools. So there are, in high schools, grade 8s who are, 13 and some are as young as 12, and grade 12 students who may be repeating sometimes. So you have 18 and 19-year-olds in that same space. And my husband is currently at an alternate school where there is a smoke pit, as with many schools, but marijuana is, we could look at the Tobacco Act and the regulations that govern smoking, but it's not quite the same. And you have to look at it similarly to alcohol, but alcohol is forbidden on campus in all high schools. And currently marijuana is as well, but smoking is allowed at the smoke pit. So you could imagine what could happen in the schools if we were to allow the social sharing provision to remain as is. And at this time in BC schools, if someone is high, they get sent home. So with this amendment adopted at committee left as is, I have great concerns of what could happen in the schools. And as you know, there's because even with a regulated, carefully monitored tobacco market, a legal substance, we do have a proliferation of contraband tobacco. And there is infrastructure within Canada, and it's an international, infrastructure as I'm aware, based on talking to some experts, and that already exists. So I don't understand how we cannot worry about what could happen with marijuana even after it's legalized, and that these criminal elements will be recruiting, and some of these students who are in the schools could very well be part of that recruitment. So I do share many of the concerns that are expressed, and for those reasons. Now, I guess what I will just simply focus on, rather than elaborating on the concerns and about what's happening with the illegal contraband tobacco market is that I think that it is our duty as senators when we're looking at legislation that if we enact this law, we have to think about its first aim, which is to protect our youth from having greater access. And I believe that the social sharing provisions will actually increase the access and put our youth at greater risk. And so we cannot go into the homes and police what happens there, as others have stated. However, at least the laws can reflect the kind of objective we wish to achieve, that the law will at least provide some limits, as Senator Plett is proposing. And if anything, if some parents are potentially deterred by these limits that we include in the bill, then we will at least have aided them through the law as well. So I just believe that the risks at school and what could happen, because these legal age students will be with underage students every day, and it will make things very difficult for teachers, for administrators, and I do believe that in time, you know, the public will be able to prepare for all the sort of extended sort of changes that they will see in their schools and in society. But at this time, the schools are just barely talking about it. They know that it's forthcoming, but they need more time to prepare. So for us, I think it's very important to be on the safer side and at least achieve some sort of balance. I understand the objectives that Senator Bernard was looking at in order to protect some of the youth who may, you know, they have their futures ahead of them. So we heard what she said today, but knowing that we're opening up the schools to even greater risk, I truly believe that the amendment that Senator Plett is proposing will give us some assurances, will set limits that will be important in light of these issues that we know will happen on the school grounds. So I know that at the committee there were many experts representing professional medical associations, health bodies, and other organizations. And many sort of recommendations were made. They were compelling. We talked about, you know, changing the age from 18 to 19 or even as high as 25. But I don't believe that anyone recommended provisions for social sharing. I think there are risks that we are aware of. And so in light of all this, and in light of the fact that we do wish to protect youth, especially at the schools, and provide some protection in the home through what we can ultimately do with the law, I urge all senators to support Senator Plett's amendment, as I will.
Senator Weston?
Would Senator Martin take a question?
Would you?
Thank you. Just a point of clarification, I probably should have asked Senator Plett this question. How did you come up with the 2 years? Is it arbitrary? Is there any basis for the 2 years?
Senator Martin?
I believe that was in the amendment that was adopted at committee that Senator Bernard proposed.
Senator.
Speaker, honourable senators.
On debate.
I struggle with this aspect of the legislation because I'm vehemently against any measure that is in any way permissive or appears to be permissive of providing marijuana to anyone under the age of 25, never mind anyone under the age of 18. However, I do see Senator Bernard's point that an 18-year-old passing a joint to a 16-year-old friend, as she says, shouldn't face 14 years in prison for doing so, and I don't think any reasonable person would disagree with that. So notwithstanding my objection to the use of marijuana by young people, I would agree with the need for an amendment to lessen the severity of punishment for just such an offense. However, I do not agree with removing penalties altogether. Doing so would fly entirely in the face of what is supposed to be the main purpose of this legislation. After all, the overarching objective of the government in passing this bill is to make sure that we reduce, actually, in long term, the marijuana use amongst young people, which is to keep marijuana out of the hands and to decrease the use amongst the youth. Again, I must repeat, notwithstanding my objection to the overall use of marijuana by people under the age of 25, and we all know the reasoning behind that. We listen to the Canadian Medical Association, Nurses Association. I haven't heard any compelling argument to make me believe that people that regularly use marijuana from the ages of 0 to 24, it doesn't have an enormously adverse effect on their cerebral development. So I strongly support the compromise being proposed by Senator Plett's amendment. I find it to be reasonable. I find it to be building from what Senator Bernard is trying to achieve, and I think Senator Plett is just making sure that we're protecting fundamentally teenagers in this country. It sufficiently addresses Senator Bernard's concerns over the severity of the penalty, and just like with the second part of her amendment, maintains consistency with how we punish similar offenses related to social sharing of alcohol, for example. I believe this balanced approach also addresses the issue we know is a problem with other aspects of this legislation, which is the increased backlog it will create in the courts. So in the interest of consistency, balance, and alleviating unnecessary courtroom backlogs, I think this is a very reasonable amendment. Social sharing is going to have the biggest impact when we legalize marijuana. We all remember when we were a little bit younger than we are now, and we recognize what was the driving force for us taking our first drink or trying our first cigarette. It's being 16 or 17 in a high school or on a football field or in a locker room and wanting to be like that 18-year-old. It's only normal. Every young teenager wants to be like the 18, 19-year-old. They want to grow up in a hurry. So if the 18-year-old is having a cigarette, well, you figure it's pretty cool. Let's try a cigarette. Let's try our first drink, our first beer. How many 15, 16-year-olds are dealing with alcoholism in secondary schools in this country? And how do they get access to that alcohol? They get it because some 18, 19-year-old buys it for them. And it's very rare that it's a friend of his that buys him the beer. It's a peer. A peer is not a friend. It's somebody you come across on a football team, because in Canada you have various leagues where 18-year-olds are playing with 17-year-olds. Very many hockey teams and junior hockey teams, you have 15, 16-year-olds playing with 19, 20-year-olds. So there's that inevitable overlap. And if we don't take measures and steps to safeguard those young teenagers that just aren't ready to make a decision of an adult, a legal adult, then I think we're negligent in our overall responsibility. So I just wanted to share those thoughts, and for those reasons I am supporting Senator Plett's amendment. Thank you.
Senator Batters, do you have a question?
I have a question if Senator Huzakos would accept it.
Senator Huzakos?
I would, thank you.
As Senator Bernard was just saying, without a definition of friend in the social sharing amendment that Senator Bernard proposed, and with no limit on the amount of marijuana that could be socially shared, wouldn't that potentially be allowing a loophole to set up a drug distribution chain?
Senator Huzakos.
Look, invariably, I think the lack of definitions on many aspects of this legislation right now, which I clearly don't think has been thought out very carefully, and here's an example of it, and that's why I think this amendment is so critical. It certainly would be a loophole, because let's face it, predators look after markets. They don't look after age groups. A predator who's out there peddling marijuana, legally or illegally, you want to legalize it, it doesn't change what the illegal market does. They try to make the most amount of money. So if making the most amount of money means making sure an 18-year-old in a dressing room is peddling product for you, yeah, he's doing it legally to other 18 and 19 years old. But if you have a little loophole when you can socially share with the 17-year-old guys in the locker room, what they're sharing is here's a joint for $10. So indeed, it can create the kind of dynamic that you're referring to.
Senator Omadvar, do you have a question?
Question. So I understand the sentiment behind Senator Plett's amendment, and he has provided an excellent table of his amendment, which I really appreciate. Thank you very much. My question is about the summary convictions in both circumstances when someone provides a young person with 5 grams or less or over 5 grams. A summary conviction can result, it depends on the judge, but it can result in a prison sentence of 6 months or less. A summary conviction does carry a criminal record with it. And given everything we heard at committee around the knock-on effects of criminalization on young people. And Senator Poirier, I have a hard time pronouncing that, I apologize, talked about how one mistake, in this case, could damage a young person's life forever because they would be denied employment, education, travel, and lots of other issues. So I wonder if you have a response to this particular concern of mine.
Senator Zakos.
Look, I'm going to be honest that I did not really look at it from that point of view, but at the end of the day, when you're trying to protect young teenagers from what is invariably a potentially harmful effect on them, there has to be some kind of sanction involved for the adults who have to understand that it is not right for them to be distributing marijuana to 16 and 15 and 14 and 13 and 17-year-olds. Again, from my understanding, the way I read the summary is I think it's a reasonable sanction and one that people have to take under consideration. I think the objective of this bill is to protect young teenagers. We've had the ongoing debate on what should be the limit of acceptability for an adult to make their own decision. And the government has determined, and it seems to be 18. I certainly don't agree with that. But an 18, a 19, a 20-year-old who takes a decision legally to smoke marijuana should also appreciate and understand he should not be selling marijuana to a 16-year-old or socially sharing marijuana to a 15-year-old. And there are repercussions that come with it. There has to be some line where, yes, parliamentarians, you have to draw.
Senator Omidyar, yes.
Senator, for that answer. So you're not concerned about damning, and this is really the word that we heard, or the sentiment that we heard at committee, damning a young person forever to a life of exclusion because of a mistake that they made. I mean, there are other provisions that Senator Platt has, tickets, which I could perhaps support because it doesn't result necessarily in a criminal record. I wonder if you can compromise the principle of the bill, which is protection of youth and decriminalization, with this amendment.
The stand gives an enormous amount of privilege to people 18 years old and above. If they can exercise that enormous amount of degree of privilege and making the freedom of the choice they make, they should appreciate the small risk involved when they don't respect the law, and us as parliamentarians draw a limit that adult should not be peddling marijuana in any shape, way, or form to a minor. I'm ready to draw that line and live with that risk to that adult who takes that risk and has to live with the consequences. There has to be some consequence for somebody 18 and up, just like there will be a consequence when he gives that doobie and that joint to a 15-year-old or 17-year-old.
A question, Senator Platt?
For one more question?
I do.
Senator, I would like to just weigh in on what Senator Omidyar said, also a little bit on what Senator Bernard said. Would you not agree, Senator Sakis, that when somebody gives a 16-year-old more than 5 grams of marijuana, more than 10 joints, that goes beyond social sharing and gets awfully close to trafficking, and then maybe a summary conviction is in fact suitable? Senator Bernard talked about 1 joint. My amendment is quite clear, 5 grams. Her amendment was entirely unclear and left no limits, had no cap, and we would just simply have no repercussion for somebody giving 10 pounds of marijuana to somebody if they were 2 years younger.
Your time is up. Senator Eggleton on debate.
Well, there are a lot of very interesting points being made here about, in terms of what social sharing means. I believe it means kids passing around a joint. I think that happens all the time. And it can happen with people that are close in age, but are somebody, or some of them might be over the age of 18, passing on to somebody that is 16, or giving them a joint, not selling them one. You get into sales, or you get into something more than 6 grams, which this amendment from Senator Plett suggests would still be an indictable offense. 6 grams, more than 5 grams would still be an indictable offense. If you're getting into something of that quantity, I think you're getting into trafficking. And I think you just said that, Senator Plett. I think you're getting into trafficking. That's not social sharing. So social sharing is what I just described, and it's what the task force recommended. Senator Bernard picked this up from the task force. And I think social sharing with somebody, the people close in age, is reasonable. Now, even Senator Plett has left alone the other part of this, where if you're at home and the parent is there, no problem. But if the parent is out of the room, in effect, or out of the building, in effect, then it's a problem if an 18-year-old passes to a 16-year-old. I think certainly the government will have to put in a definition of social sharing. But I think this amendment, coming on the heels of the task force amendment, and I think that gives a clear understanding of what this is about, I think it's reasonable to do this. As I said earlier, I don't think anybody should be criminalized for possession or personal use. Trafficking is a different matter. But, and this would still expose young people. Young people are not just the people under 18, but people who are 18, 19, 20, they're still young people. They're still people that can be affected very profoundly in their life by a conviction. And I think the amendment that was adopted by the committee on the proposal of Senator Bernard is a reasonable one to proceed with.
Question.
On debate, I have Senator Dean before you.
Okay. Thank you. Thanks, Your Honour. And I will. Oh, sorry.
Oh, I'm sorry. I'm sorry, Senator Martin.
That's okay.
Senator Eggleton, would you accept the question?
I'm looking for my iPhone. Oh, no, sorry. Yes.
Okay. I hope you find it.
And it's charged.
Okay. Okay, well, I didn't include this in my speech earlier, but I did receive a link to an article today in Global News. I don't know if you've seen it. And it talks about the concern about the social sharing provision in the federal law, because many provinces have adopted their new laws around legalization of marijuana, and social sharing is illegal in those provincial laws. So I was wondering if there had been, if you're aware of any consultations about social sharing with provinces, because our law, in effect, will go against the provincial laws that have been passed.
Well, I'm afraid takes precedent. Federal criminal law takes precedent, but there are some parts of it that are delegated to the provinces, and if the provinces are operating within that framework that is delegated to them, then they're free to do that. Just when we talked about the 4 plants, you wanted to abolish having any plants at all, but we ultimately said let's leave that to the provinces. Now that's one that's delegated. I don't know whether this one is delegated offhand. I don't know what consultations there have been on it, but unless it has been delegated to them, it still is a federal responsibility.
Senator Martin?
Well, I think the problem is that this was an amendment that was adopted. It wasn't in the original federal law. And in the meantime, provinces have enacted their laws, and any sort of sharing of the marijuana to minors is illegal in provincial law.
Sure of that.
Well, it's in today's article. I was just wondering if you had read it. It's by Patrick Kane.
I haven't read the article. It doesn't mean it's correct, but it might be fake news. No, I'm not saying it's fake news, but I'm not sure I'm not sure of its accuracy. But again, if it's part of the federal law, then that prevails.
Senator Dean, on debate.
Thank you. I'll be brief, Your Honour. I want to build on the points made by Senator Omidvar and Eggleton. I support Senator Bernard's original amendment. It is consistent with the philosophy of Bill C-45, which is to reduce the criminalisation of young people. This is something that we heard about in committee and in committees, a concern about remnants, perhaps too many remnants of criminalisation left in the bill, and concerns about the criminalisation of young people. This is clearly what was driving Senator Bernard's original amendment. It's clearly not about trafficking, which is dealt with in other parts of the bill. And I'd like to kind of question or contest this notion that this will start a problem. This is responsive to an issue. It's responsive to the fact that kids share cannabis fairly widely. Not just within a 2-year band of 18 or 19, but as we know, down to as low as the age of 12 and 13. This is a problem that we have now. This is a problem that we're going to try and tackle with education and with more information and harm reduction. So, you know, when 1/3 of 15 to 19-year-olds are reporting past use of cannabis, they're getting it somewhere, and they're probably getting it in lots of cases from their peers. So I support this motion, the original amendment, and I would say this, that I don't think that was an amendment coming from Senator Bernard, and in fact promoted by witnesses at our committees, that was based solely on the concept of social sharing. I think it was predominantly built on the foundations of the notion of closeness of age, which is defined, which we find elsewhere in the criminal law in Canada. That the notion that where there are margins of age, that this should be recognised. It's close. It's likely going to happen commonly, and we're not going to immediately jump to charging people. So this is built on closeness of age. Yes, it's about social sharing. It's obviously not about trafficking, and it is consistent, without a doubt, with the overall emphasis, one of the key planks of the legislation, which is to reduce and attack the criminalisation of young people, and particularly marginalised Indigenous and other racialised Canadians, who we know are multiply represented in the justice system over and above those of their peers. So I'm going to continue to support this, so I'll oppose the amendment.
Do you have a question? Senator Dean, will you accept some questions?
I'm just waiting for the mic. Thank you very much. I appreciate your intervention in this. I think it's entirely possible for two positions to be correct, and I'm feeling like that's the situation here. I agree with Senator Bernard's amendment and her intent completely when you're talking about social sharing in the context of sharing a joint around a room. I agree with Senator Plett completely if you're talking about someone who's 18 or 19 handing over a 10-gram bag to someone who is underage, and that there have to be some sanctions. To me, the simplest way of solving this is to actually have a definition of social sharing in the legislation. My question to you is, do you not think it's reasonable to preclude the events that Senator Plett points to by having that kind of a definition? Because his concerns, I don't think, are unwarranted.
Senator Dean.
Well, given that you and I are having this debate, Senator Lankin, it clearly is possible for two people to be right. And so And so, of course, I will acknowledge, as I will with most of the toughest aspects of our discussion about cannabis reform, that there are at least two, and in many cases more than two, views on how to tackle a particular challenge. And that is certainly true of age of legal access, which is, you know, why we have a discussion between age 25 and age 18 and 19. Our job here is to figure out what is the most appropriate way of balancing those things. There will be different points of view. They're all legitimate points of view. On balance, it was my view, and it remains my view, that given what we know about young people, given what we know about the intent of the Act, that this is, you know, I land with Senator Bernard on this, while recognising that there are other legitimate points of view here, and not discounting them at all. This is a tough issue on which there are a number of points of view, and our job in all of the critical and toughest areas of Bill C-45 is to figure out the way that we will bridge those gaps and resolve those differences. You know, one potential way is a definition of social sharing. I don't know that we've got time for that, and this is an important issue. So as things stand, on balance, I still lean towards supporting Senator Bernard's original amendment, but it's a great question. Thank you.
Senator Zakos, une question?
Just a very brief question. Senator Dean, I've been hearing you throughout this whole debate over the last little while, and again, I'm more concerned with your last intervention than ever before. I keep hearing how the government talks about their objective being to reduce the consumption of cannabis amongst young people, yet I listen to you articulate in this discourse on this particular issue, and you don't seem to be that concerned that what this bill is doing is it's normalizing the use of cannabis. Our main preoccupation is to make sure that adults 18 and above don't get in any shape, way, or form criminalized in any shape, way, or form, including when they give X amount, 4 grams, 5 grams, 3 grams, to a 14-year-old or a 15-year-old. And how do you square those corners? At the end of the day, there's a reason, I suspect, why the task force and this legislation has the admissible age of use of 18 and above. So why don't we just go down to 16 if we listen to your dialogue and resolve this problem, or 14, or 13 for that matter. So I really can't understand how the government seems to be so flayé about the idea that there's going to be more accessibility for young teenagers to getting access to marijuana through social sharing and other means, and we've taken no steps. And can you share with us what steps has the government taken in order to prevent these young people from access through social sharing of any form?
Senator Dean?
Look, I'll be very brief, and I'm going to answer just the first part of the question, or the early part of the question, and I will say this, that in 2002, your colleague, Senator Nolan, concluded after an extensive study of cannabis in Canada that prohibiting cannabis was more harmful to young people than to legalizing it and strictly regulating it. For the past 16 years, we've been thinking about that, and we've been doing more research, and we've been having discussions, and we've had expert task groups. And you know what's happened in the last 16 years? And this isn't going to comfort you much. That's 16 more years of normalization while legislators have been looking the other way. So the news I have for you, Senator Husakis, is that I think that cannabis in Canada is much more normalized already than you'd like to think it is, or that you'd like to hope that it is. So that's my answer to your question. Well, that's the answer you're going to get.
Senator Stuart Olson on debate.
Thank you. I just wanted to add a bit to this debate. I support the amendment. I don't support the original amendment that we passed in committee, mainly because I think it disrespects our young people. I don't believe that an 18-year-old is dumb enough to think that it's right to give and to share a drug with younger people. I don't believe we should be saying that it's okay if you do by saying there are no consequences. I just think that we have to perhaps give them the respect they deserve, and as Senator Dean was saying, strictly regulating, well, in my opinion, it is not strictly regulating if you say it is okay to do that and there are no consequences. I think that Senator Plett's amendment relaxes a lot of the of criminalizing. I certainly think it's not going to criminalize people, but I do think that we have to teach our young people, and we are responsible for that. We have to teach them. We bear the responsibility to say, okay, you're the up-and-coming generation. You are responsible for your younger peers coming along as well as we are. And I don't want to disrespect them by saying to them, you go ahead and you share this any way you want to. I think we should give them more credit than that. And I think that by saying, you know, there's an age that has been decided where it's okay, and you just have to wait for that. I'm not going to say it's fine to socially share, because number one, I don't know what that means. And number two, it's not fine. And no kid that I know thinks it is fine. They all know it's not. And I can't look a parent in the face and say, yes, I agreed that that was okay, because I know a lot of parents who are going to look at us and say, it wasn't okay that you did this. Thank you.
Are senators ready for the question? In amendment, it was moved by the Honourable Senator Plett, seconded by the Honourable Senator Martin, that Bill C-45 be not read. Dispense. Are you in favour of the motion? Those in favour of the motion will please say yes. Yes. Those not in favour of the motion, please say nay. Nay. Oh, it's so close. I think we'd better have a vote. Do I see two people standing? Do the yeas. No, it was even. It was even.
That would mean the nays have it if it's even.
So if it's even, the nays have it. So we're going to have a vote in 15 minutes. So the clock will be 8:32. Call in all the senators.